Hi, everyone. Harry here to talk about the Ninth Circuit decision staying the grant of relief that District Court Judge Chuck Brier had granted in the whole California kerfuffle involving the federalization of the National Guard and at least potentially, says California, the use of the military and the Marines to potentially enforce domestic laws in a way that the Posse Comitatus Act and very sort of strongly embedded constitutional and cultural principles say should not be happening except in the most exigent of circumstances in the United States of America. Okay, so very briefly on Brier, which we've talked about before, he sets a fast schedule, then he, at lightning speed, produces a 36-page opinion that basically grants relief, a temporary restraining order. I'll get back to that in a moment, but that says, look, under the structure of the statute that the administration is relying on, Title 10, Section 12406. It's the judiciary that first makes a determination, is there a rebellion here, or is the federal government unable to execute the federal laws? And then, and only then, do we turn to the assertion of authority, where we do give some deference to the facts of the administration. And doing that, Brier finds we don't have a rebellion and we don't have a situation where the United States is unable to enforce its laws. All right. Enter the Ninth Circuit. A 3-judge panel, 2 Trump appointees and 1 Biden appointee, issues a unanimous per curiam opinion. Per curiam, we, I think, know what that means at this point, but nobody signs. It's just a way of saying all 3 of us agree. So it kind of firms it up as a statement of the entire panel. And they reverse Brier, sorta, kinda. Let me go through what they've done and then get to the sorta, kinda part, okay? So they go to 12406 and their basic beef, it's a pretty vague opinion when you really get to the rationale for what they're doing, okay? But they go to, there's a 3-part test in 12406, and one of them is there a rebellion? That was the focus of Brier. Here, the focus that the U.S. is really raising is, are we in a situation where the United States is just unable to enforce United States law? And basically, they say yes under a heavily deferential standard. And that issue of deference, I've suggested before, is really the big ticket, both for this dispute, but more generally. Will the courts, and especially the U.S. Supreme Court, if it comes to it, say something like the administration's position, which is you can't second guess us in any way? If Trump said expressly, I'm doing it because it's Tuesday, not for any of the 3 reasons, you would just have to stand down and let him do it. Okay, so importantly, and the California governor sort of trying to make the most of what really is a adverse decision, emphasizes the court does reject the administration's absolutist position. It says at many different points, it's not true that any of the laws we're talking about, any principle we're talking about, authorizes the sort of free pass without review that the administration is stridently arguing for. So they do say there's some review. On the other hand, the sort of error they find in what Judge Brier did below, and it's, as I've said before, pretty vague, is you have to be really deferential to the administration. How deferential? It ain't clear. And why deferential? Let's start there, because as Brier pointed out, this isn't even international law or foreign policy. This is what they're doing in LA, but the court rejects that and says it's the same statute, so you can't interpret it differently for a domestic setting and an international setting. We have to give it the same kind of construction. And here it's just gotta be pretty deferential, sort of deferential, more deferential than Brier did. Really not much more than that. And it matters because what they point to are just a few episodes of clear kinds of, hooligan moves that really were, violent protesters who did stuff. And there's no doubt there were some of them, California says, and the overwhelming weight of the evidence seems to be that those episodes were isolated. Those are the things that arise in domestic law enforcement settings. California had a full kind of handle on what was going on, didn't need the feds, and this doesn't count as a rebellion, nor does it remotely count as a situation where the U.S. or the states are unable to actually enforce the law. But if you had to try to put in a sentence what all three now of the judges say, it would be something like, with a heavily deferential review, these few episodes of blocking traffic, using shopping carts to barricade the streets, throwing some mortar-style fireworks at customs, that's enough. Under a heavily deferential standard, which we have to do, and the district court erred in not doing adequately to say he's got the authority under 12406. Now, to me, that's a really potentially broad holding that suggests that, as Trump and Tom Homan and others have said, we're going to have a repeat of this scene again and again. Trump has come out on Truth Social and said, we've got to go into all these democratic cities, those are his words, where there's been terrible failures and they are overrun with marauders. And at least if this opinion holds, it seems like he can do it. One rock breaks one window, and with a lot of deference, that can qualify under the statute, which again says, that it's too much for the states to handle. They are not, by the way. There's been suggestions around the edges of this litigation that the administration is suggesting it has inherent constitutional authority under Article 2. That's not what the Court of Appeals took up here, and really not the submission that the administration made. Rather, it's a straight up interpretation of Title 10, Section 12406. And without getting too deep into the weeds, I'll just say that there is a lot of reliance on this over 200-year-old opinion that the otherwise pretty taciturn Biden-appointed judge invoked in the oral argument. And in that case, the president had said, we've got a rebellion, called up troops, and a person said, I'm going to give my own interpretation here of whether they did. I disagree with the president. And that was struck down, obviously enough, but I think it's very different from the situation here, though the court talks about how that broader principle has abided over these 200 years, etc. Okay, so let me go to the sort of kind of part now. Because things have changed a lot on the streets, including that they're quiet. So to the extent this relies on a sort of factual record that is now overtaken by events, it may be of limited applicability. More importantly, Brier had, after giving his temporary restraining order, had said, I'm going to go ahead and do a preliminary injunction hearing on Friday. That would be today. And the Ninth Circuit hasn't done anything to stop that. So there's a weird way in which this case is now playing out on dual levels. there's a whole very arcane legal issue that comes up again and again that I'll just cite without delving into, which is, when does a court of appeal have the authority to stay a so-called temporary restraining order as opposed to preliminary injunction? They're normally not supposed to, but if it functions as a preliminary injunction, they can, blah, 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 blah. But they found that it was the case here. Notwithstanding which, we have in very short order this hearing for a preliminary injunction on the facts as they now are on the ground. One important point is, I mentioned this was only under Title 10. We now have at least one instance where the military has come in and made an arrest. That's something that can happen only under the Insurrection Act, which Trump has not invoked. The current state of play under, if you federalize the National Guard, is those couple thousand people for 60 days or so can be there to protect property and federal personnel. It's a whole bigger step for the military to be authorized, and would have to be, I think, under the Insurrection Act to basically do law enforcement, as at least one of them has done. That's I think what you could summarize as a posti comitatus act principle, because it's that act that says this can't be done except in very narrow exceptions, like the Insurrection Act. So that might be part of the focus that's going on below. Or the administration might argue this really hasn't happened yet, so it hasn't come up, so there's no dispute. We'll see how if that's the issue that Brier focuses on. But in general, A, Brier is still going to go forward and maybe issue a ruling. But B, as I read this Ninth Circuit ruling with its vague application of a supposed deferential standard of whether the U.S. is able to enforce the law on the ground, it's the sort of thing that I think could green light similar operations as have happened in L.A., in cities around the country. And Trump and Tom Homan have both said that's what we want to do. Stick around because those are coming. So I think the state of play here is that there'll be a general sense this can happen. That itself has a pretty corrosive effect, right? Federal, forces are coming into states that don't want them, but it makes that kind of accepted or part of the backdrop for the American people, and just gets us a giant step toward a militarized state. Now, of course, the Ninth Circuit opinion could either be sort of limited as just about this issue and the facts a week ago, or more likely, California, as the feds do all the time, could try to challenge it. Could either ask the Ninth Circuit to hear it en banc, little asterisk here, that's such an enormous gargantuan circuit of 28 judges. They actually hear en bancs, and the first instance as mini big panels of 13, not 28, and those are chosen randomly, or could appeal it to the Supreme Court. My political read, and that's not my expertise, but my political read is California is wanting to just be past this. Things are calm there. The governor has made a point of the supposed victory in the case, that at least they don't green light complete deference to the administration. So I don't know if we can look to California to push this to the Supreme Court level. And if it stays where it is, again, let's see what Chuck Brier, the district court judge, is going to do in his separate hearing. It seems like it might give a general, if not green light, at least a kind of fait accompli feel to doing the LA dance of federal dance in city after city, starting with Chicago and New York. So in that sense, it could be a broad and I would say pernicious opinion, even though the bottom line here is it's not exactly clear what they're saying, but they're basically saying more deference than Brier gave, but not absolute deference. And that, of course, the refusal of absolute deference is the bottom line, most important thing if Trump were to receive what he wanted, including from the U.S. Supreme Court in this case, of just all he has to do is say 10 U.S.C. 406 and he can do whatever he wants, we'd be really hurting because he would be very much unabashed about lying and sort of applying it anywhere and everywhere. At least for now, no court has endorsed that absolutist position. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.